Dateba, Samuel Kofi Dateba's book, Reflections on the Supreme Court of Ghana, June 2015. He identifies a problem with the empaneling at the Supreme Court and captures it as follows. The Chief Justice's power to empanel judges confers on him or her arguably the opportunity or potential to influence the outcome of particular cases. The Chief Justice's knowledge of an individual judge's track record on particular issues or his or her judicial inclinations on particular issues may give the Chief Justice this potential. This, rightly or wrongly, has attracted unfavorably, let's end it there, that the knowledge of the Chief Justice about judges can influence, the empaneling. Do you agree with Justice Dateba? If so, why? If you don't, if so, why?
Thank you, Honorable Chair. I believe that in the empaneling of judges, the Chief Justice performs an administrative function. Now, this administrative function is a function that has been given her by the Constitution. And I do not believe that it would or should influence the kind of decisions taken on the bench, because the Supreme Court justices of the bench are experienced, independent-minded jurists who should be able to take independent decisions. Thank you very much.
Any follow-up? Thank you. I'll proceed to recognize Honorable Buama, Junior Buama.
Thank you very much, Mr. Chairman. My lady, congratulations on your nomination.
Thank you very much.
My lady, you are being elevated to the highest or the apex body in our judicial system, which is the Supreme Court. Can you share with this committee 2 major decisions you've made in your career that you would be remembered for? And can you share with this committee what really the contents of those decisions were?
Very well, Honorable Chair. The first I would mention is that I co-authored a judgment in the treason case, Republic versus manpower. To the best of my research, this may very well be the first test case under the 1992 Constitution. My checks tell me that there's no appeal pending, but even if there should be an appeal pending, I think that this is a judgment that would chart the path and be a reference for future cases. And also I would like to say that there is another ruling, not a judgment, that I authored in the case Later versus Later. It went to the Supreme Court on appeal, and the Supreme Court reinforced its previous decision in the Ojiadom case, which says that even though an application for stay of execution, even though there can be an application for stay of execution in respect of executable judgments, it is also possible to grant a stay of execution in non-executable judgments, especially so when the execution of that judgment would have executable consequences. So, thank you very much.
Any follow-up? Now proceed to give the floor to Honorable Anthony.
Thank you, Mr. Chairman. Welcome, my lady, and congratulations on your nomination.
Thank you very much, Honorable.
My first question let us look at delays within the administration of justice, within the courts. Could you tell this committee why so many delays with simple land matters? Sometimes some of them travel for 6 years, 7 years, 9 years. Even simple matrimonial matters, 5 years, 6 years. What are some of the reasons you would attribute for these delays?
Thank you very much, Honorable Chair. One of the very first reasons is that we do not have enough manpower to be able to expedite the cases that we have. I would give an example. When I was in the family or divorce court, at a point in time, you could have 300 and over cases, and that's just one court. And that is just one judge who has to determine all these cases. And we should remember that as these cases are being determined, new ones are being filed on a daily basis. So the first thing is lack of manpower or enough judges to be able to expedite these cases. I would also say that another cause for delay is the procedures and processes, especially the interlocutory applications. So many repeated interlocutory applications can stall cases, especially when you give when there's an application before you and you give a decision, and your decision is stayed. It means that you probably and your decision is taken to the higher court and the case is stayed. It means that you would have to stay your hand until the matter is determined. Another thing is also that we need to be able to look at the procedures, timelines for filing pleadings, from the stage of filing a writ of summons to the stage of filing your pleadings to the application for direction stage. Is it possible to shorten the process so that we can expedite the cases? That is what I'll say for now. Thank you very much.
Now, from your answer on procedure and processes, are you then suggesting that the rules of court are too complex? It's been argued by some people that the rules of court are too complex for ordinary Ghanaians who do not have legal representation. Would you recommend that the rules of court are made very simple, very basic for everybody to understand so as to help expedite the way and manner cases progress in court?
Thank you, Honorable Chair. For me, it's not the complexity of the rules of court, but the timelines may have to be looked at. Because if you have to file a writ of summons and statements of claim, and it will take you about 22 days for the other party to file a defense, we may have to look at it and see if we can shorten the timelines to be able to expedite the filing of pleadings. In that case, we could speedily resolve these disputes. So for me, it's not the complexity, but the timelines. Thank you, Honorable Chair.
My second question, I was trying to do some academic exercise on my own this morning, playing the devil's advocate at the same time. I looked at the CI-47, particularly Order 1, Rule 2. Then I asked myself if all the other orders following after Order 1, Rule 2 help promote the aims and objective of the CI-47 as contained in Order 1, Rule 2. Order 1, Rule 1, 2, yes.
Well, my recollection of Order 1, Rule 1, 2 enjoins the courts to ensure that matters are speedily and effectively determined. But since the rules guide the court is guided by the rules in determining these matters. And as I have already said, the Rules of Court Committee may have to look at the timelines for filing of pleadings until when the pleadings are closed and the trial actually starts after applications for direction stage. So I think the timelines may be considered. Thank you, Honorable.
My lady, my next question is, don't you think that the problem has to do with post-directions, the procedure where there are no timelines? Is that not where the problem is, where that is subject to the discretion of the court?
Honorable Chair, can I have a clarification of the question? I don't seem to.
But what I'm saying is that after the application for direction stage, there are no clear timelines. Yes, as to when trial should commence. Is that not where the problem is?
We can't have timelines for completing trials. But as I indicated earlier, that would also depend on the number of cases that a court has. Because if a court has 300 cases and 100 of the cases are ripe for trial, definitely some would have to abide other cases. And that is when you are going to have a backlog of cases. So if we are going to have timelines for trial of cases, then we have to address the issue of the number of cases per judge. Then we can give effective timelines for determination of these cases. Thank you, Honorable Chair.
Thank you very much, my lady. My last question, third and last question. Your sister, my lady Janabari, was here yesterday, and as an answer to a question on the activities of the legal aid, she suggested that young lawyers being called to the bar must be made to do some service over there to help reduce the burden on the ordinary Ghanaian who cannot pay for legal service. Do you agree with that?
Thank you, Honorable Chair. I think it's a good suggestion. But I would also say that if the Bar Association does not already do so, the Bar Association should encourage every lawyer to do some amount of pro bono work. I think this will go a long way to assisting with the problem. Thank you, Honorable Chair.
Very grateful, my lady. I believe every lawyer does pro bono. The chairman would agree with me. Even in matters where you charge a fee, sometimes when you are done, they refuse to pay. So that's pro bono.
That there is a remedy available for you to recover your fees. You have a remedy under the law to recover your fees. Thank you very much. I will then proceed to give the floor to Alhaji Omar.
Thank you, Chairman. Congratulations, my Lordship. Happy Saturday, Amaleboba. I'm so happy to see you, and looking at your CV and your background, I'm happy because it gives hope to our daughters and our sisters from the region where we come from.
Thank you, Honorable Chair.
My question to you this morning is, what do you hope or want to be remembered as a justice of the Supreme Court of Ghana.
Thank you, Honorable Chair. I want to be remembered as a hard-working judge, one with integrity, an assiduous judge, and one who sets precedent that will stand the test of time. Thank you, Honorable Chair.
Thank you.